So, very good evening, friends. Welcome to our batch specially created for discussion on case studies. But before we start the sessions on case studies, let me take you to a brief overview of IBC. IBC, as we know, on one side is the central government and on the other side is the judiciary, Supreme Court. Central government, by way of notification, notified IBBI is the regulator for this insolvency and bankruptcy code. The website where very useful information regarding rules, regulation, acts, disciplinary cases available is at IBBI website. So on IBBI website, ibbi.gov.in, you can download the BEAR Act, rules, regulations, disciplinary cases, etc., etc. IBBI is regulating the professionals, insolvency professionals and insolvency professional entities. It is also regulating the insolvency professional agencies, and it is also regulating the information utilities. To become an insolvency professional, you are aware that you have to pass this limited insolvency examination, for which we are all here. Then you have to go for 50 hours of pre-registration educational course. And then you have to enroll yourself with IPA and you have to get yourself registered with IBBI. And you can assume different roles like IRP, RP, liquidator, bankruptcy trustee, administrator, etc., etc. There are three agencies as of now: IPS IPICI.in, then IPAICMAI.in, and ICS-IP.com. So with any of these insolvency professional agencies, you can, after passing the limited insolvency examination, can enroll yourself, and that agency will impart you 50 hours of practical training and then will give you enrollment, and then thereafter you have to register yourself with IBBI. Regarding this information utility, there is only one information utility as of now. National E-Governance Services Limited. For corporates, for part 2, application can be made by financial creditor, operational creditor, and corporate debtor. The adjudicating authority under IBC is NCLT in case of corporates and DRT in case of individuals. Appellate authorities accordingly are: for NCLT, NCLAT is the appellate authority, and for DRT, DRAT is the appellate authority, and thereafter the Supreme Court comes. Role of High Court is very limited. It is just limited to overseeing whatever was the award given by NCLT. Regarding these case studies, we have identified certain particular fields on which we will be developing case studies. You can let us know in case you want a study on a particular topic, like related party is one of the important concepts. And it is given in section 524 and 524A. This is 5. Then who cannot be a resolution applicant? There are certain disqualifications, 29A. Then on CIRP, we'll be developing case studies on PUFE transactions. Today, we'll be discussing these related parties and PUFE transactions. Then on liquidation, on this fast track, not fast track. Voluntary liquidation, then pre-pack insolvency resolution process, on professional ethics, on individual insolvency and allied laws. So we intend to cover 40 to 50 case studies. Probably we'll be covering 50 case studies, and minimum we will be having 20 sessions, maybe even more if it is required. So let us start with section 524 first. I think all of you are having copy of the BEAR code with you. So section 524, what it says? Let me open a copy of the BEAR code also. Is it visible now, चट्टोपाध्याय जी?
हाँ सर, हाँ सर, हाँ
ये
सर।
बेयर कोड वाला विजिबल है ना?
नहीं, बेयर कोड वाला विजिबल नहीं है।
विजिबल नहीं है, ओके ओके। अच्छा, मैं अभी कर देता हूँ इसको।
कर।
इसको स्टॉप शेयर करके। Now I think it must be visible.
No, no sir.
नहीं, अब तो नजर आना चाहिए.
नहीं सर, नहीं, नो सर.
नहीं आ रहा.
Mhm.
कोई बात नहीं, अभी शेयर कर देता हूँ दोबारा. अब नजर आ रहा होगा.
नहीं आ रहा है. हाँ, आ भी है.
आ
नाउ
गया
इट
ना.
इज. हाँ, ओके सर, नाउ.
हेलो. हाँ जी. तो we can open section 524A. Although I have given it in the PPT also, but कोई यहाँ से बेयर कोड से पढ़ना चाहे तो बेयर कोड से भी पढ़ सकते हैं. अब 524 क्या बोलता है? This section 524A says related party in relation to a corporate debtor. So there are two types of related parties. For seeing whether a particular party is a related party or not, we have to see its relation in relation to a corporate debtor or in relation to an individual. So related party of whom? Related party of a corporate debtor or related party of an individual. So related party in relation to a corporate debtor means a director or a partner of the corporate debtor. And corporate debtor, as we know, normally includes a company or an LLP. Although there are some others also, but mainly it includes a company or an LLP. So a director or partner of the corporate debtor or a relative of a director or partner of the corporate debtor. So in case XYZ is a company, so the director of XYZ, any of the directors or partners of XYZ LLP, they will be the related party. Or a relative or any of the relatives of director or partner, they will also be related party. And who are relatives? This definition is given in section 524A. Similarly, KMP of a corporate debtor or a relative of KMP. Then LLP or partnership firm in which a director, partner, basically these are the persons who can influence. So who can influence decision making in a company? And for related party, the period of coverage is more. Related party, what is the logic to study this concept of related party? Because in case of related parties, you have to be more vigilant as to the type of transactions entered into with such persons. So that is why we have to identify whether the transaction which has been done by the company is with a related party or an unrelated person. And sometimes in case of a related party, there is a presumption also, and that this transaction was not carried out in good faith and so on and so forth. In a public company in which a director, partner or manager, here the holding is more than 2%. So if it is 2% exactly, then it is not covered under relative party. So we have to watch and see each and every word very carefully. The holding normally is more than 2%. So more than 2% does not include 2%. So it will be 2.1 or more. Any body corporate whose board of directors are accustomed to act, any LLP. So these are the persons basically who can influence decision making. So this is the long list of related parties. Similarly, section 524A. Although detailed videos are already available on my YouTube channel, Chattopadhyay ji will be sharing a link of the YouTube channel with you in the group of which you have already been added. This 524A, this is a related party in relation to an individual. So a person who is a relative of the individual or a relative of the spouse of the individual. So relative of the individual or a relative of the spouse of the individual. Then a partner of limited liability, because here in relation to an individual, they will be covering basically the relationship with an individual, because the business may be conducted or the entity which is under IBC may be an individual or a corporate person. In case the entity covered is a corporate person, then we have to see section 524. And in case it is an individual or say it is a partnership firm, then we have to see this related party in relation to an individual, and we have to see the provisions of section 524A. So a person who is a relative of the individual or a relative of the spouse of the individual, partner of LLP or LLP or partnership firm in which the individual is a partner. Then trustee of a trust in which the beneficiaries of the trust includes the individual, or the terms of the trust confers a power on the trustee which may be exercised for the benefit of the individual. So this is a long list of the persons who are covered under related party in relation to an individual. And relative here means members of HUF: husband, wife, father, mother, son, daughter. Up to this, it is very clear. But now, son's daughter and son. So, son of son and son's daughter of son. Daughter's daughter and son. So, son of daughter and daughter of daughter. Then, granddaughter's daughter and son. Granddaughter's daughter and son. Brother, sister, brother's son and daughter. Sister's son and daughter. Father's father and mother. So, it means grandfather and grandmother. Then, mother's father and mother. So, maternal grandfather and maternal grandmother. Father's brother and sister, and mother's brother and sister. And wherever the relation is that of a son, daughter, sister, or brother, their spouses will also be covered. Suppose it is father's brother. So, father's brother, wife is also covered. Suppose the relation is of father's sister, then father's sister's spouse or husband is also covered. Okay? So, these are the definitions which we have to see, section 524 and 524A. Now let us go back to our previous slide. This was the PPT we were referring to. So related party we have seen. I have already highlighted in this the various important things. Chattopadhyay ji, I hope this is visible.
नहीं नहीं ठीक है
ठीक है ना?
नहीं वो तो मैं बताऊंगा नहीं आने से बताऊंगा
Okay. So now illustrations for related party. See, let us see some of the relations. Related party, it appears in various places. 524, 524A, 524(1), then proviso to section 21, second proviso, section 28, section 29A, 32A, section 43, 44, 46. So these are some of the sections where the concept of related party comes. Now let us see illustrations for related party. XYZ Company Limited is a pharmaceutical company working in the field of medicines, having 4 directors: A, B, C, D, A, B, C, and D in its board of directors. X, being a PhD in medicines, is the KMP of the company, working as a research analyst for 15 years. So X is the son of C's granddaughter. So you have to see the relationship also. Now Z. So in XYZ, ABCD are in board of directors. X is KMP. Now there is another person, Z. So Z is the son of C's granddaughter. So you can have a pen and paper and you can write the relation so that you can understand whether it will be covered or not. So you can write son of C's granddaughter. So son of granddaughter. So you have to see whether son of granddaughter is covered or not. I think son of granddaughter is covered. Granddaughter's daughter and son. If in section 524A, if you see the clause number this 11, granddaughter's daughter and son. So granddaughter's son is covered here. Okay, I am referring to section 524A explanation. Achha. And working as manager in XYZ company. D is a partner in an LLP namely ABC Consultants, providing finance related services. Now examine the related party. So first is a director or partner of the corporate debtor. Because A, B, C, D, they are all directors. So they are all related parties. X is KMP. X is also a related party. But you have to see it the clause wise. So this in 524A, all the four A, B, C, and D will be covered. This X will be covered in 524B, KMP of the corporate debtor. Then Z is the son of C's granddaughter. This will be covered in 524A subclause 10, granddaughter's daughter and son. and D is a partner in an LLP. Acha, namely, D is a partner in an LLP. Now, D is the director also. D is director in XYZ. Now, whether D is a related party of D is otherwise also related party. But the question here is whether ABC Consultants is a related party or not. So, LLP in which a director, partner or manager of the corporate debtor or his relative is a partner. So, this will also be covered in 524C. I hope this is all clear. Now, let us see this illustration. Sun Pharma Company Private Limited is a pharmaceutical company working in the field of medicines having 4 directors. अच्छा ये तो हो ही गया ना, ठीक है. Now Z holds 2.5% of the paid up share capital of Sun Pharma. I think I can unmute all now. देखो कोई disturbance अगर नहीं करेंगे तो I can unmute all, कोई issue नहीं है ना? Otherwise we can converse through chat. It is up to you. So Z holds 2.5% of the paid up share capital of Sun Pharma Company. Examine the related party. So what is the clause for this? For coverage, suppose we want to cover this Z. So Z holds 2.5%.
More than 2%, sir.
More than 2%. Okay? And it is a private company. In private company, the concept is more than 2% of its share capital.
Public share paid up capital होना चाहिए.
हाँ, in case of public company, it is more than 2% of the paid up capital. So Z जो है, Z is a related party. Next is what could be the related party status if D, although being a director, do not hold any part of the paid up share capital of Sun Pharma. Suppose D is a director, but he does not hold any share capital. Then no, also sir. Whether it will be a related party?
No, sir.
क्यों?
Both conditions should be satisfied. He should be directors and holds more than 2%.
No. Either of these conditions should be satisfied. So a director, whether even if he does not hold any share capital, he will be a related party by virtue of clause 524A. So as per clause 524A, A में हो गया तो वो देखना ही नहीं है. If he is a director, then he is a related party, whether or not he is holding any share capital.
Okay, sir.
Because this D is a director of this company. है ना? So D is a director, and although he does not hold any share capital, even then he will be a related party. I hope now it is clear.
Yes, sir.
Next. What could be the implication if Z holds 2% of the share capital?
Should be more than 2%, sir.
Now, there is a difference between the earlier question and this question. In earlier question, D was the director. So by virtue of being a director, we don't have to see anything, whether he's holding any share capital or not. So if he's a director, then he's a related party. But here, Z is not a director. Z is the son of D's granddaughter and working as manager. Granddaughters, daughter and son. So 524A 11. So he is also a related party in relation to an individual. But here we are saying it's in relation to a company. Okay? Now Z's relationship we have to see vis-a-vis the company, this Sun Pharma. So now Z is holding 2% of the paid up share capital of Sun Pharma company. So because he is not holding more than 2% and he is not a director, then he is not a related party. क्यों चट्टोपाध्याय जी?
हाँ सर, वही तो बोला.
So a private company in which a director, partner or manager of the corporate debtor is a director and holds along with his relatives more than 2% of the share capital. So in case it is exactly 2%, so is not covered. Okay. But had it been a partnership firm, this Sun Pharma proprietorship, then he would have been a related party, because there the concept is in relation to an individual. और इंडिविजुअल में आपको क्या देखना है, बॉडी इंडिविजुअल में फिर आपको यू डोंट हैव टू सी दी शेयर कैपिटल. Related party in relation to an individual, here also you have to see in relation to a related party in relation to an individual. So in case of a private company, you will see individual is a director and holds along with the relatives more than 2% of its share capital. So he will not be a related party, whether it be relation to a corporate debtor or in relation to an individual. So this will be, the answer is given in 524A D clause. A private company in which the individual is a director and holds along with his relatives more than 2% of its share capital. So accordingly, you have to see it clause by clause. A private company in which a director, partner or manager of the corporate debtor is a director and holds along with his relatives more than 2% of its share capital. Next देखते हैं. Sun Pharma Company Private Limited is a pharmaceutical company working. These four are the directors. Gulmohar Management Consultants Private Limited is a LLP working in the field of management related services. Now B is one of the partners of Gulmohar Management Consultants. Okay. Now Z is the son of B's mother's sister and working as manager in Gulmohar Management Consultants. Gulmohar Management Consultants owes a sum of 75,000 to Sun Pharma Company Private Limited. B and Z both holds 1% of the paid up share capital. So this B and Z both holds 1% of the paid up share capital of Sun Pharma. Examine the related party under section 524. Now let us discuss this. चट्टोपाध्याय जी आप डिस्कस करिए क्या है ये.
नहीं आप देख लेते हैं.
हाँ देखिए, Sun Pharma is a pharmaceutical company. ABC are the directors. Now the question is whether ABC and D are related party. Yes. Now regarding this Gulmohar, let us see. For Gulmohar, what we have to see is an LLP. Okay. So LLP and B is one of the partners. So let us identify the clause where this will be covered. So it is covered under LLP. LLP is given in 524C. A limited.
520, he is a partner of the LLP. If it is a partner of the LLP. 524C.
LLP or partnership firm in which a director, partner or manager of the corporate debtor or his relative is a partner. So now he is the partner. He is the partner. And Z is the son of. He is one of the partners. Okay.
He is one of the partners. That is individual relative, sir.
No. We relationship we have to see vis-a-vis the Sun Pharma Company Private Limited.
Okay. It's corporate debtor.
So we are seeing whether this Gulmohar and Sun Pharma are related or not. Now, this B is one of the partners of Gulmohar. So B will definitely be a related party.
Related party of the Sun Pharma.
By virtue of 524C.
524C.
Now let us see. This Z is the son of B's mother and sister. Acha. Now Z is the son of B's mother and sister. Acha. Son of B's mother's sister. Okay. So mother's sister, mother's brother and sister is covered here. But their son is not covered. Mother's brother and sister is covered, but
mother's brother and sister.
हाँ. क्या बोल रहा है? Z is the son of B's mother's sister. So mother's sister is covered, but mother's sister's son is not covered.
Son is not covered.
ठीक है ना? So accordingly you have to see. And he is working as manager in Gulmohar Manager Consultants. So now this Gulmohar Consultants owes a sum of 75,000 to Sun Pharma Private Limited. B
The
and Z both hold 1% of the share
1%.
capital. So B and Z, although they are holding 1%, but together they will be holding 2% only.
2%. That is
And the condition is more than 2%.
more than 2%. It is
So
not
there also they will be excluded.
in group. That is 1%.
Mhm. Next is, what could be the related party status if B, although being a director, do not hold any part of the paid up share capital of Sun Pharma Company Limited. Now B is a director. So if one is a director, then you don't have to see the shareholding. I know. So what could be the implication if Z holds 2% of its paid up capital of Sun Pharma? Now B is holding 1%, Z is holding 2%. So together they will be holding 3%. So it will be covered under related.
That is as in the family associate persons.
Yes. Now let us see this. ABC Limited is a public sector undertaking working in the field of bioagricultural products. Actually, the case study will be more complicated, but we are starting with simpler versions. Let us first understand simple cases, then we'll move on to more complex cases. So AB, because first of all, we have to learn to study the section and we have to identify under which particular clause this will be covered. And all these clauses are mutually exclusive. So it is or. Not that all the clauses have to be satisfied. So if any of these clauses is satisfied, then it is a related party. And you have to see the relationship also, whether the relationship is as regards the corporate debtor or relationship is in relation to an individual. So that also you have to see. Now ABC Limited is a public sector undertaking working in the field of bioagricultural products. Okay. Now XYZ Private Limited is a private company providing biotechnological services having 3 directors, namely A, B, and C. So there are 2 companies. One is ABC, another is XYZ Private Limited. This is a public sector undertaking, ABC. And XYZ, it is a private company. And it has got 3 directors, A, B, and C. Sun Care Services is a LLP providing finance related services. Now this XYZ private, so there is another company which is Sun Care Services. So Sun Care Services is you can say as an individual or a partnership firm because it is a LLP. Okay, it is an LLP. So this is also a corporate debtor. So we have to see the relation to a corporate person. So Sun Care Services is LLP, XYZ Private Limited, and ABC Public Sector. So there are 3 entities. Now, this Sun Care Services is LLP. XYZ Private Limited owns a sum of rupees 2 lakhs to ABC. XYZ is the XYZ owes rupees 2 lakhs to ABC. Okay. C, a director of XYZ Private Limited is also a director in ABC Limited. And he and his relative Z both hold 1% of the paid up share capital of ABC Limited. Sun Care Services owes a sum of 75,000 to ABC Limited. Alpha, a partner of Sun Care Services, is also one of the directors of ABC Limited, and he and his relative Gamma, they hold 2% and 1% of the paid up share capital of ABC Limited respectively. Why a manager of Sun Care Services also holds 2.5% of the paid up share capital of ABC without enjoying the director. Actually, you have to write all this on a piece of paper and then examine closely the relationship. But as a thumb rule, you can notice 2 or 3 major things. Number one is the holding should be more than 2%. If it is exactly 2%, then it is not a related party. If the relationship is of a director, or a manager, then you need not even see the shareholding. If, and all these answers you have to provide in the group. I've already shared this PPT with you, and you can provide the answers in the group, and then we can discuss if it is required. A public company in which a director, partner, or manager of the corporate debtor is a director and holds along with the relatives more than 2%. So a public company in which a director, partner, or manager of the corporate debtor is a director. So if this is a public company, now this ABC is a public company, and if any of the directors of ABC is a director in some other company and along with his relatives, the shareholding has to be seen along with the relatives. Then you have to see whether it is more than 2% or not. Now ABC, so is it, why a manager holds 2.5% without enjoying the. What could be the implication if Y is one of the relatives of C? Now in this case, this XYZ Limited is having three directors A, B, and C. Now, if say he says कि Y is one of the relatives of C. So if there is a relative, then you have to combine. We have to combine the shareholding. C is a director, he is holding 1%, and Y is holding 2.5%. So together their holding will be 3.5%. So if Y is one of the relatives of C, then Y's shareholding will be clubbed with the shareholding of C. So for this shareholding, you have to see the holding of the director, partner, or manager along with his relatives. So you can go through all these illustrations and then try to identify the particular clause under which this fits in. So holding company definition is also given. So section 246, because this 524, it refers to holding company also. This 524J, if you see a body corporate, which is a holding subsidiary or an associate company of the corporate debtor or a subsidiary of a holding company to which the corporate debtor is a subsidiary. So for this, we have to see the definition of holding company, subsidiary company, etc. also. So holding company, as you have to see the definition as per Companies Act. Certain definitions are not given in IBC. So for that, you have to refer to the Parent Act. Like for holding company, you have to see the definition as per Companies Act. So section 246 of the Companies Act defines holding company. The company is said to be holding company if that particular company holds or owns at least 50% of the other companies and has the authority to make management decisions, influences, and controls the company's board of directors. So this is in nutshell about holding company. Types of holding company: pure, mixed, intermediate. You can go through all these things. Subsidiary company. So if the parent company is the holding company, then it is a subsidiary company. How many subsidiaries? All these things you can go through. It's a very detailed presentation. Now, along with this definition of relative, so you have to see the definition which is given in section 79. Because IBC, it applies not only to corporates but to individuals and partnership firms. So as far as individuals and partnership firms are concerned, we have to see the definition of associate. So associate is something similar to a relative. So associate of the debtor means a person who belongs to the immediate family of the debtor, a person who is a relative of the debtor or a relative of the spouse of the individual, a person who is in partnership with the debtor, a person who is a spouse or a relative of any person with whom the debtor is in partnership, A person who is employer of the debtor or employee of the debtor. A person who is a trustee, a company where the holding is more than 50%. So for relative, then you have to again go to the definition of 524A and 524. Let us see this illustration. Sun Pharma Company Private Limited is a pharmaceutical company working in the field of medicines having three directors A, B and C. Their respective shareholding in the company are this. This is the shareholding. Now Sun Pharma Company Private Limited owes a sum of 22,50,000 to Moon Corporate Services, out of which D is also a director, holding 38% of voting rights in that company. So in this company, Sun Pharma, there are three directors, A, B, and C. D is not a director in Sun Pharma. So now, but Sun Pharma owes a sum of 20,50,000 to Moon Corporate, of which D is also a director, holding 38% of voting rights in that company. So now you have to see the related party under section 524. And these are the various scenarios. If D along with C controls the voting right in the company under a voting agreement, what if B dies and Gama, the son of B, who is a minor, is entitled to the share of B? What if D dies and Kamal Tarangini, his daughter, who happens to be a minor, entitled to the share of D? What if C dies and Kamal Priya, the only child and the stepdaughter of C, entitled to the share of C? So, in case there is a succession of ownership, then that person is also clubbed in the shareholding. And whether it be stepdaughter or minor, so they are all, their ownership of or shareholding is clubbed together for this purpose. So this was something about 524. Regarding IBC, you know that this IBC is a time bound mechanism for resolution of economic stress of a corporate entity or an individual or a partnership firm. A company or an individual or a partnership firm comes under IBC because there is some financial trouble. But now the objective of IBC is to extricate the entity or the individual or partnership from that trouble, from that financial trouble, and possibly see a resolution to that economic stress, but that too in a time bound manner. So these are the timelines for such purpose. And for this PUFE transactions, which is the subject of today's discussion. So first of all, the RP has to form an opinion of preferential and other transactions within 75 days. So first of all, he has to form an opinion whether at all this transaction, which I am seeing, is a preferential transaction or not. Then he has to make a determination within 115 days. Okay, this is a preferential or other transaction, which is avoidable transaction. It is a PUFE transaction. Then he will determine, okay, finally this is determined as PUFE transaction, and then he will file an application to adjudicating authority for appropriate relief within 135 days of the commencement of the insolvency commencement date. So these are the timelines for identification, for forming an opinion, determination, and filing an application: 75, 115, and 135 days. These are the various forms which have to be filed by the resolution professional. And for this, he has to file CIRP 8. This the resolution professional shall file form CIRP 8 intimating details of his opinion and determination under regulation 35A on or before the 140th day. So we have seen the timelines as 75, 115, and 135. So by 140th day, he has to file form CIRP 8 and he has to intimate details of his opinion and determination under regulation 35A. Now let us see What is this section 43? 43, let us now open section 43 regarding these preferential transactions. Okay, what are these preferential transactions? As we know, there are 4 types of transactions: preferential, undervalued, fraudulent, and extortionate. So first of all, see what are these preferential transactions. Let us read from the Bear Code. So we can again open the Bear Code and we can read from the Bear Code. So I think this is now visible.
Visible.
So now let us see, let us open section 43 in this. And I'll point out the major issues in this. 43, what it says? It says preferential transactions and relevant time. So first of all, who is to identify? Liquidator or resolution professional. So if a question comes, okay, who will be identifying the preferential transactions under section 43? So primary responsibilities of the liquidator or the resolution professional. If he is of the opinion that the corporate debtor has at a relevant time given a preference. So who is the giver? Who is giving the preferential treatment? Corporate debtor. Okay. In such manner as laid down in subsection 2 to any person, and to whom this preference is given. The preference is given for the benefit. It need not be given to a particular person, but if it is for the benefit, it says to any persons as referred to in subsection 4, he shall apply to the adjudicating authority for avoidance of preferential transactions. Now, when it is deemed to have given preference, if there is a transfer of property, so there either has to be a transfer of property. By preference देंगे कैसे? How will he give preference? He will give preference either by way of transfer of property, or he will transfer an interest thereof of the corporate debtor for the benefit of a creditor or surety or a guarantor. Okay. So there are two parties. One is the corporate debtor. Corporate debtor is on the giver side. Corporate debtor is giving preference. To whom is giving? He is giving the preference for the benefit. He need not give the preference directly to the creditor. But even if it is given for the benefit of a creditor or surety or a guarantor. So the words important here are for the benefit of a debtor. It need not be necessarily to the creditor or surety or guarantor. So if a question comes, okay, whether the preference need to be given to creditor or surety, no, not necessarily. It should have been given for the benefit of a creditor, or suppose it is given to the brother of the creditor, or if it is given to the party of the creditor, then but if the ultimate aim is to give benefit to the creditor, then it will be covered under section 43. So we have to see whether there is a transfer of property or interest thereof of the corporate debtor for the benefit of a creditor or a surety, or so the word for the benefit are also very important, or a surety or a guarantor for or on account of an antecedent financial debt or operational debt or other liability. What is this antecedent financial debt? Antecedent financial debt or operational debt is some earlier debt. Suppose there was an earlier debt. There were some convertible, redeemable convertible debentures. Now, when they became due, they were converted into a loan. So those redeemable convertible debentures, that transaction is antecedent financial debt. So if it is a conversion of an earlier liability, you can understand antecedent by say conversion of an earlier liability. So what you are doing? You are converting an existing liability into some other form. Earlier, it was redeemable convertible debentures, but since the company did not have the funds to pay, so it converted them into loan. So the earlier transaction will be known as the antecedent financial debt. So it need not be necessarily a financial debt. It could be an operational debt also, for or on account of an antecedent financial debt or operational debt or other liabilities owed by the corporate debtor. And the transfer under clause A has the effect of putting such creditor or surety guarantor in a beneficial position than it would have been in the event of distribution of assets. So where from you have to see section, you have to see its relation with section 53, because section 53, as we know, talks of waterfall mechanism. Section 53 sets out certain order of priority of payment to various parties, to secured creditors, to unsecured creditors, workers, employees, government dues. So there is a set priority as per section 53. Suppose section 53 is a line, different people, 6 people are standing in that line. Now if you call somebody who is at the sixth position to come forward, you make him payment prior to the persons who are earlier in line, then you are deemed to have given preference. So this payment has to be in accordance with section 53. So this 43 you have to read with section 53 also. And for the purpose of subsection 2, a preference shall not include the following transfers. So there are certain exclusions also. What are the exclusions? Exclusions are if it is in the ordinary course of business. Then you have created a security interest by creating some securing new value. Securing new value means earlier you were having 100 crores as loan. Now you raised some other loan of say 50 crores. So now the loan amount is 150 crores. So for availing that additional loan, you provided some additional security, then it is in order. Okay? It means creating a new value. But suppose the loan amount is same and you are increasing the security, then you are giving some preferential. So transfer made in the ordinary course of the business or financial affairs of the company. So transfer in ordinary course is excluded. Then any transfer creating a security interest in property acquired by the debtor to the extent such security interest creates new value and was given at the time of or after signing of security agreement that contains a description of such property as security interest and was used by the corporate debtor to acquire such property, and such transfer was registered with an information utility on or before 30 days. So these conditions are cumulative. So both these conditions should be met. There should be some new value. It should be at the time or after signing the security agreement. It's not that you have already signed some security agreement, you already created some security 1 year before, and now you are giving that security. And such transfer has to be registered with information utility. As of now, there is only one information utility, NESL. So that transfer should be registered with an information utility on or before 30 days after the corporate debtor receives possession of such property. So both these conditions, if they are met, then it will not come under preferential transactions, provided that any transfer made in pursuance of the order of a court shall not preclude. Shall not preclude means shall include, because not preclude, it will not preclude, it will not avoid, it will not take out. So even if there is a court order that you transfer this property, so even if it is in pursuance of a court order, it can also be a preferential transaction. Why? Because the logic is that courts also look to the limited facts put before them and they give their judgment accordingly. And if the liquidator or the resolution professional is of the opinion that there is some alteration in the priority of payment, or they are giving security unnecessarily without creation of new value, then they can include in preferential transactions. Explanation. For the purpose of subsection 3, securing new value means money or its worth in goods, services, or new credit. So new value need not mean new loan. It could be some goods or services also, or new credit, or released by the transfer of property previously transferred to such transferee in a transaction that is neither void nor voidable by the liquidator or the resolution professional under this code, including proceeds of such property, but does not include a financial debt or operational debt substituted for existing financial debt or operational debt. But suppose there was a financial debt earlier. Now you substitute that existing financial or operational debt with some new debt. So that is not it. And preference, for this preference, you have to see the concept of a related party. Related party concepts we have already seen in 524 and 524A. If it is given to a, that is why I discussed this concept of related party before discussing this section 43, because you cannot understand section 43 unless you know the definition of a related party. So if it is given to a related party other than by reason only of being an employee. So if he's a employee, why? Because 524, it includes an employee also. Let us see section 524 again. This concept of employee, basically it will cover either the manager, or if you see the definition of associate also, there also the concept of employee comes. So in if it is an employee, then it will not be covered by in this related party concept. So for related party, the period of transaction is 2 years preceding the insolvency commencement date. And insolvency commencement date, we all know, is the date when the application is admitted by the adjudicating authority, which is NCLT in case of corporate persons. And a preference is given to a person other than a related party during the period of 1 year. So in case of unrelated person, it is 1 year. In case of related party, it is 2 years. So this is in brief section 43.
Sir, this chart is very good, sir.
Huh?
In this copy, chart is very good. 1 to 6, one number of examples are there in chart. I
Huh?
prefer transactions. The one point is this:
Huh?
payment of all tax dues. What there is exist a risk of prosecution without any order from the court of the authority. That is preferential transaction.
Huh? I've included
It's a
various
very good.
examples.
It's a very good, sir. It's a
Huh.
very good. Well, there is a uncommon questions.
Yeah, yes.
Question number 6.
Yeah. But let us discuss first from the code and then we'll again go to the presentation.
Okay, sir.
And now 44, because ultimately you have to read from the code. So 44 says key order in case of, now once a transaction is preferential transaction, there are 2-3 things which you have to note in case of preferential transactions. In case of preferential transactions, there is no mention of any monetary amount or value. So it could be some creation of new security. It need not involve transfer of some amount. So without amount also, without giving any amount, the transaction could be a preferential transaction. Okay? Suppose an unsecured debt you are converting to some secured debt, so it is a preferential transaction. Now, what are the orders which can be passed by the adjudicating authority? So adjudicating authority, basically the effect is reversal. So what they will do? Require any property transferred in connection with the giving of preference to be vested in the corporate debtor. So earlier, corporate debtor transferred the property to some other person. The other person was creditor for the benefit of creditor, surety or guarantor. Now that transaction will be reversed by the adjudicating authority. Require any property to be so vested if it represents the application either of the proceeds of sale of property so transferred or of money transferred. What does it mean? It means actually the property was transferred and then that property was sold. Suppose under section 43, a transaction was done by the corporate debtor and he transferred some property for the benefit of the creditor. Now that creditor also sold it. So now this under B, it will be covered under B. Require any property to be so vested if it represents the application either of the proceeds of sale of property so transferred or of money so transferred. So the converted portion will also be restored back. Third is release or discharge in whole or in part of any security interest. So if you have created an security interest, you have made unsecured as secured, it will again become unsecured. Require any person to pay such sums in respect of any benefit received by him from the corporate debtor, such sums to the liquidator or the resolution professional. So if some person has received some benefit, he will be required to pay it back. Direct any guarantor whose financial debt or operational debt owed to any person were released or discharged. Suppose there was a guarantor. Now you release that guarantor. So there was some benefit to that person. So it says, okay, bhai, now what you do, you will be responsible for that position. So it may also include direct for providing security or charge on any property for the discharge of any financial debt or operational debt under the order, and such security or charge to have the same priority as security or charge release or discharged. Okay. So the position, the person uh, who was released or discharged, he may again be saddled with that liability. Basically, this is what is meant. But there is a concept of, if something is acquired in good faith and for value, it will not affect any transfer in property which was acquired from a person other than the corporate debtor. So if the property was acquired from any person other than the corporate debtor, if it was acquired from the corporate debtor, then it will not be excluded. But suppose there the corporate debtor transferred it to a, for the benefit of creditor, and then creditor transferred it to some other person, and that other person acquired that property in good faith and for value, then it will not be affected. Or require any person who received a benefit from the professional transaction in good faith and for value to pay a sum to the liquidator or the resolution professional. Okay? What is the logic behind this? By logic is, a corporate debtor transferred a property to C. C took some value and transferred it to D. So naturally that amount or the property or the value is still lying with C. So from C the amount will be recovered. What is the point in recovering from D, who has acquired in good faith and for value? Take it, because the amount lies with C. So in case it was done in good faith and it was acquired for value, then it will not be affected. For the purpose of this section, it is clarified that where a person who has acquired an interest from another person other than the corporate debtor. Okay? But suppose that other person had sufficient information कि भाई CIRP is going to commence. Sufficient information of the initiation or commencement of insolvency resolution process. This concept is called twilight zone. As we know, before this sunrise, there is a twilight between the night and the sunrise. So there is a feeling that sun is soon going to rise. So similarly, if he had sufficient information of the initiation or commencement of insolvency resolution process of the corporate debtor, then this will not be excluded, or is a related party. In case of a related party, it shall be presumed that interest was acquired or the benefit was received otherwise than in good faith, unless the contrary is shown. So if you are a related party, even if you say, okay, I paid the money for it, I acquired it in good faith and for value, even then you have to prove it. Okay? So you have to show. A person shall be deemed to have sufficient information or opportunity to avail such information if a public announcement has been made. So if it is a public announcement, it is a fact, though it means you are presumed to have knowledge of the initiation. And after that public announcement, if some property is transferred to you, then you have to give it back. Okay? Even if you raise the plea that you acquired it in good faith and for value, even that plea will not work, because you had sufficient information of the initiation or commencement of insolvency resolution process. And in case of a related party, it is always, the presumption is always, unless it is rebutted. So this was regarding 43 and 44. Now let us see avoidance of undervalued transactions. What are these undervalued transactions? These undervalued transactions are, suppose you give something for free, or you give it for consideration which is significantly less than the original price. So it says, if the liquidator or the resolution professional, on an examination of the transactions of the corporate debtor referred to in subsection 2, determines that such transactions were made during the relevant period under section 46 which were undervalued, he shall make an application to declare such transactions as void and reverse the effect of such transactions. And undervalued is if you make a gift to a person or enters into a transaction with a person which involves the transfer of one or more assets by the corporate debtor for a consideration the value of which is significantly less than the value of the consideration provided by the corporate debtor, and such transaction has not taken place in the ordinary course of business of the corporate debtor. Relevant period, same, 1 year, and in case of related party, 2 years. And the adjudicating, but there is another aspect to this. In case of undervalued, you it because the concept here is you have given it for free, or you have to given it for consideration significantly less. Now who will assess? Suppose you have transferred a property worth rupees 100 crore at say 20 crores. Now you might say that the value at present is only 20 crores. It was 100 crores when it was purchased, but now it is 20 crores. Now who will assess? So the adjudicating authority may require an independent expert. So they will appoint an independent expert to assess evidence relating to the value of the transactions mentioned in this section, because this value definitely may be subject to challenge. So this is regarding relevant period for undervalued transactions. Then section 47, application by creditor in case of undervalued transactions. Suppose in case of undervalued transactions, this resolution professional or liquidator does not file. So in case, suppose undervalued transaction has taken place, liquidator or resolution professional has not reported, then a creditor, member or a partner of the corporate. Now you might ask why a member or partner will report. Because a member or a partner, suppose there are 10 directors in a company. All directors may not be interested in hanky panky. So one of the directors who is an honest person, he also might report to the adjudicating authority that, my lord, they have done this transaction. They have done this undervalued transaction. So even a member or a partner of the corporate debtor, as the case may be, may make an application to the adjudicating authority to declare such transactions void and reverse the effect. And what the adjudicating authority will do? It will do, first of all, it will assess that undervalued transaction has occurred, and the liquidator or the resolution professional, as the case may be, after having sufficient information or opportunity, did not report such transactions to the adjudicating authority. Because section 47 says that any other person, application by creditor in case RP or liquidator do not report to adjudicating authority. Then besides restoring the position, it will require the board to initiate disciplinary proceedings also against the liquidator or the RP. And order will be similar to the provisions which we have already seen in 44. So, 44 you can read with 48, orders in case of undervalued transactions. And 49 is transactions defrauding the creditors. So in this case, where the corporate debtor has entered into an undervalued transaction as referred to in subsection 2 of section 545, and the adjudicating authority is satisfied that such transaction was deliberately entered into by such. So the transactions, undervalued transaction may or may not be deliberate. If it is not deliberate, then it will come under undervalued transactions, 45. But if it is deliberate, then it will come under 49. So in 49, there is an intent. There is an intent to defraud. But in 45, there may not be an intent to defraud. Okay? So this is the basic difference between 45 and 49. So in this case, the corporate debtor has entered into an undervalued transactions as referred to in subsection 2 of section 45, and the adjudicating authority is satisfied that such transaction was deliberately entered into by such corporate debtor for keeping assets beyond the reach and in order to adversely affect. So then it will restore the position as it is, and it will protect the persons who are victims. But same the concept of acquired in good faith and for value, and it shall not require a person who received it. Now, extortionate. Extortionate may be regarding the financial or operational debt both. Okay? Extortionate credit transaction. You are interested in a particular party. You take premises on rent from someone whom you are close, and you say, I will pay you 20 lakhs rupees per month as lease rent. The property is worth 5 lakhs only per month rent. So you are taking it, you are taking the money of the corporate debtor out of the company through this transaction. So such type of transactions are extortionate credit transactions. Or you agree to some terms of a loan which are unreasonable. So this extortionate credit transaction, it could be involving receipt of financial or operational debt. Okay? And the period is 2 years preceding the insolvency commencement date. So in this case, there is no concept of related party or unrelated party. So in this case, the period is 2 years preceding the insolvency commencement date. Okay. And for the purpose of this section, any debt extended by any person providing financial, suppose there is a credit card company, suppose Citibank is charging 36% interest per annum. Even then, it is not a extortionate credit transaction. But if it is from a private person, a private financer who is charging say 10% per month, so then it will be extortionate credit transaction. But you have availed financial services from someone who is in compliance with any law, so then it will not be considered as extortionate credit transaction in no event. Okay. And 51, then it talks of order of adjudicating authority, basically restoring the position. ठीक है, तो हमने यहाँ क्या देखा, इसमें देखा हमने 50 में the period is 2 years and there is no concept of related or unrelated party. So this was regarding 43 to 51 we have covered. Now let us see section 66. चट्टोपाध्याय जी, कोई उसमें कोई कमेंट हो तो बता दीजिएगा चैट में, कुछ ऐसा हो सीरियस हो तो, क्यों मैं उधर देख नहीं पाता हूँ. So 66 says fraudulent trading or wrongful trading. Now sometimes the business is conducted in a fraudulent manner. So section 66 talks of this. If during CIRP or liquidation it is found that any business of the corporate debtor has been carried on with intent to defraud creditors of the corporate debtor or for any fraudulent purpose, the adjudicating authority may, on the application of RP, pass an order that any persons who were knowingly parties to the carrying on of the business in such manner shall be liable to make such contribution to the assets of the corporate debtor as it may deem fit. So in this case, in section 68, they are making the directors or partners personally liable. So on an application made by a resolution professional during the corporate insolvency resolution process, the adjudicating authority may by an order direct that the director or partner of the corporate debtor, as the case may be, shall be liable to make such contribution to the assets of the corporate debtor as it may deem fit. Then it talks of twilight zone also. Before the insolvency commencement date, such director or partner knew or ought to have known that there was no reasonable prospect of avoiding the commencement of a corporate insolvency resolution process in respect of such corporate debtor. That means the director or partners knew that this ship is sinking. So they will be made personally liable, and such director or partner did not exercise due diligence in minimizing the potential loss. Okay. Then proceedings under section 66. Basically, they are making the person liable. Now let us again go back to our PPT. So this 43 we have seen. 43 basically talks of preferential transactions. 44, 45, 46, 47 we have all seen. The definition of associate related party we have already seen. So there are 40 preferential, undervalued, extortionate and fraudulent transactions. So in this case, there is a transfer of property or transfer of an interest, and property will be money, goods, actionable claim, land, every description, whether it is situated in India or outside India. And who will be the beneficiary? Creditor, surety or guarantor. So what you have to see? So first of all, you have to identify the transfer of property or interest by you want to term a particular transaction as preferential transaction. So definitely you have to convince the adjudicating authority that, my lord, this was the property or this was the interest which was transferred. Then you have to determine whether the transaction is with creditor, surety or guarantor. That also you have to identify. Third is there is some pre-existing financial or operational debt, and such transfer results in putting such creditor surety in a beneficial position. So you have to make a comparison with 53 also. That, my lord, as per 53, he was at number 6 in the line, and now he is paid in priority to the other persons. Relevant time, as we have already seen, 2 years or 1 year. These are some of the examples which you can go through. Okay, these are the examples. Suppose there is an allotment of flats or plots by a real estate company to supplier of goods or services before CIRP. Suppose there was a supplier of goods, supplier of cement. So supplier of cement, he will be an operational creditor. Now you cannot, you are not in a position to pay to that person. So what you do? You allot him flats. So by allotment of flats, you are making him a financial creditor. He was an operational creditor. Operational creditor comes down the line in section 53. So you have altered the priority of payment. So this is a preferential transaction. There are some debit balances and some credit balances of other parties. So you adjust them. So you are adjusting the debtors with creditors. So this will come under preferential transaction. Payment of secured debt against which the property of the directors is mortgaged. This would also be considered as preferential transaction. Directors have given their property as mortgage and you are paying them. So you are paying the payment of secured debt against which the property of the directors is mortgaged, because you are paying to directors in priority to other persons. Undervalued transaction, we have already seen. You are giving it for free or you are giving it for a consideration significantly lower. So what again, 2 years and 1 year in case of undervalued transactions also. Sale of luxury cars owned by the corporate debtor to related parties on related parties at a value which is much less than the market value of the car. So, but in this case, the adjudicating authority may appoint an independent expert also to value. But suppose the value is much less than the market value, then it will be considered as undervalued transaction. Okay? These are some of the examples which you can see. Fraudulent transactions. The transaction here was made with intent to defraud the creditors. Okay? These are the examples. So you are manipulating the books of accounts or other records. Okay? You are using forged documents and records to obtain sanction and disbursement of credit facilities, bogus exchange bill, sale bill for discounting, export and import bills, falsification of books. Suppose sometimes you avail credit facility against book debts and those bills are fake. So these are all the examples of common fraudulent transactions. Extortionate. In case of extortionate, the period is again 2 years and 1 year. अच्छा, just a minute. Extortionate में देख लेते हैं. Extortionate में I think it is 2 years only. इसमें कोई relative और unrelated का नहीं है कुछ. 50, let me see. Yes, it is 2 years in case of all the parties for extortionate. There is no concept of 1 year or 2 years. But in case of provider of financial services, then this is not applicable. These are the examples. So you have taken unsecured loan from related parties or other than related parties at exorbitant interest rate and unfavorable condition. Yes, it is covered. But you are availing loan from NBFC, say Citibank at 30% per annum interest, then it is not covered because it is covered under financial services provider. Okay? Against corporate cards, that is also not covered. Now let us see this. There is some distinction between fraudulent trading or wrongful trading. In case of fraudulent trading, the intention, there is the concept of mens rea. The intention is evil. Dishonest intention is there in case of fraudulent trading. But in case of wrongful trading, it is done recklessly or negligently, but fraudulent intention may not be there. So element of knowledge along with dishonest intention. So here the element of negligence and type of liability, criminal as well as civil liability, and it attracts only civil liability. Look back period in case of preferential and undervalued transactions, it is 1 year or 2 years. For related party is 2 years. For other than related party, it is 1 year. Okay. But for extortionate, it is 2 years, whether it is related or unrelated. And for defrauding creditors and for fraudulent trading, there is no period. You can go back even up to 10 years. It is not limited to 1 year or 2 years. And this is the timeline. We have already seen in the timeline. Within 75 days, you have to form an opinion. Within 115 days, you have to make a determination. And within 135 days, you have to file an application. Regarding this red flag, IBBI, they published a document, red flagging, and that document is that is available on IBBI website. But these are some of the findings of that red flags. So you can go through this. So this PPT I've already shared it with you, and you can go through this. So let me show you something else now. Now please read this case study on PUFE transaction. I hope it is visible to you. चट्टोपाध्याय जी आप पढ़िए एक बार जरा. चट्टोपाध्याय जी हैं क्या?
हाँ sir. ABC Limited, having 3 directors, namely A, B, and C, had taken a loan of rupees 100 crores from National Bank. On default of 4 EMIs, National Bank filed an application under IBC. Ramlal was appointed as IRP and was later confirmed as RP. While going through the books, IRP observed that C, who happened to be a daughter of Director B, had taken a residential loan and ABC Limited had given a guarantee towards the loan. Some of the installments were paid through the company's account by debiting B's loan account. Okay. Besides, the ABC Limited had taken
So this was the first transaction.
first transactions.
First transaction is payment of installment of loan taken by relative of director through company's account. Although they are debiting B's loan account in company, B's loan account is being debited because B is a director. But whether this transaction will be covered under P, U, F or E, preferential, undervalued, fraudulent or extortionate. Next. बाद में देखेंगे सर. हाँ जी, हाँ जी.
हाँ sir. Besides, the ABC Limited had taken unsecured loan of rupees 25 lakhs from ABC Consultant LLP, in which A's father was designated partner. During past 2 years, EMIs of rupees 5 lakhs had been paid to ABC Consultants LLP.
So this is another transaction.
What are the transactions? Loan of rupees 5 lakhs from ABC Consultant LLP. ABC
because we are seeing the CIRP of ABC, but ABC has taken unsecured loan, and now they are paying.
Okay.
ABC had taken unsecured loan because this payment has to be, once a company is under CIRP, you have to ensure provisions of section 53. So any payment you have to make in accordance with section 53 only. Here you are paying something in priority other than section 53. Because it is an unsecured loan. So naturally, first of all,
under the 53 by C.
Yes.
That's it.
First of all, you have to pay to secured, then to unsecured.
Unsecured loans.
Next, ABC Limited.
ABC Limit had to also venture into real estate business. XYZ Estates had supplied raw materials towards construction of a residential tower. There was an arbitration clause in the agreement between ABC Limited and XYZ Estates. By virtue of arbitration clause, ABC Limited agreed to offer a residential unit to the partner of XYZ Estates.
So this is another transaction. Actually, this XYZ Estates, he is a supplier of raw material. He is an operational creditor. So to an operational creditor, you are offering a residential unit. So you are making him a financial creditor because a home buyer is covered under this financial creditor. So you are converting the operational debt into financial debts. And both are at different priority as per section 53. Next.
Ramlal had appointed Mr. Mukul, his grandsons, as the forensic auditor.
Acha. Now Ramlal, who is Ramlal?
Mr. Grandsons, grandfather's sons.
नहीं रामलाल है कौन पहले ये तो देखिए रामलाल, who is Ramlal? Ramlal is IRP and now RP. So you have to see the relationship with the RP. So the question here is whether IRP or RP can appoint his relative grandfather's son. So grandfather's son will be father?
No, sir. Related party, it comes under the related party.
Grandfather का son कौन होगा?
Grandfather का son नाती होगा sir.
नहीं 524A में देखिए एक बार.
524.
Let us see 524A.
Grandfather's sons. Granddaughters son. Granddaughters.
एक ये आएगा नहीं इसमें. He is not covered.
It is not covered.
Father's father and mother. So father's father is grandfather. So grandfather and grandmother are covered, but beyond that they are not covered.
Father's son.
देख लीजिए आएगा कि नहीं. I don't think it will be covered.
Son, daughter, sister, brother, resolution.
But if you see 524A subclause 16, it says father's father. So father's father is grandfather. But grandfather and grandmother only are covered.
But
their
grandfather's son's not covered.
not covered. So he can be appointed.
He can be appointed. He is not related to the individual. Okay, sir. Okay, sir. ABC Limited had gone some jugglery in the books of real estate division. Suppliers worth rupees 2 crores were found non-existent.
Sometimes what the company does is they just inject some fake bills into the company and they take out the money. So they just entered some bills worth 2 crores. They were non-existent. Nobody filed claims. So how you will find whether they are existent or not? Because once there is a public announcement, people will file claims and they have to file claims along with the related documents. So they have to produce the documents also. So here they were found non-existent. Yes, Uma ji, please. उमा जी को अनम्यूट कर देते हैं. आप अनम्यूट कर सकते हैं. हाँ उमा जी प्लीज पूछिए. हाँ
So
मैडम.
if he is grandfather's son, he could be a father, or if it is maternal grandfather, he could be mother's brother. So that will be included in the relative.
नहीं, grandfather's son का किसमें इंक्लूड होगा? कौन से क्लॉज में इंक्लूड होगा ये?
If he could be, 1 second, sir. If he could be grandfather's son, that means he could be a father, or he could be mother's brother. If it is maternal grandfather, he could be mother's brother. Both will be covered, sir.
No. What I'm saying is father's father and father's father and mother. So father's father is covered. So grandfather is covered, but grandfather's son is not covered.
Grandfather's son could be either maternal uncle or father itself.
Yes. हाँ ठीक है, तो वो आ जाएगा उसमें. ठीक है. हाँ, so he will be a related person.
Yeah, how say? नहीं sir, please repeat sir.
भाई देखिए ऐसा है, grandfather's son ऐसा है भाई. I am RK, ठीक है. Now my father is SK, suppose, and his father is PK. ठीक है. Now PK is my grandfather and grandfather's son is SK, so he is my father.
Okay.
ये तीन रिलेशनशिप है ना. There are three parties. ठीक है. I am RK, my father's name is SK, and my grandfather's name is PK. ठीक है. So SK is son of PK. He is the son of my grandfather.
Okay, he is the father first.
Father हो गया, father ही हो गया ना. Grandfather son father हो गया. हाँ ठीक है मैडम प्लीज. हाँ जी.
Thank you, sir.
नेक्स्ट. हाँ जी. तो fake bills 2 crores. Next. हाँ चट्टोपाध्याय जी पढ़िए प्लीज. Besides this,
Mukul,
suppliers were agreed that the actual supply was 1 crore. Sometimes what happens is actual is less than the what is entered in the books. They entered in books 3 crores, but actual was 1 crore and 2 crore was given back as cash. Sometimes this also happens. And income tax and GST
had also initiated proceedings against ABC Limited for income tax evasion and GST evasion. The demands raised by the income tax department and GST departments are rupees 2 crores and rupees 1 crore respectively.
Next.
ABC Limited also into mining business. The forensic auditor observed that ABC had entered into royalty agreement with local mining contractor. Royalty was payable at the rate of 10% of the value of the minerals extracted on lump sum basis. ABC Limited had specifically stated in the royalty agreement that any liability accruing to third party shall be to the contractor's account. The mining contractor has defaulted on PF dues of the labor engaged at the site. Total PF dues were rupees 50 lakhs. Beside this, the royalty which was earlier 10%, was drastically reduced to 3%. The person given was that the extraction of minerals in the mine had gone drastically. Year's production figure are as follows. 10, 11, 12, 13, 1,800 million tons, 7,000, 6,000 in tons.
So basically, it has now been reduced to 60% of the original amount, but they have reduced it from 10% to 3%. So it will also cover, and it will also come under extortionate credit transaction. Because वो क्या करते हैं भाई 10% है, 10% का आप 6% कर लो, उसको 3% कर लिया. What happens is they take the rest of the money in cash. So I'll share this case study also, and I'll post some questions also on this, and then you have to reply accordingly. Okay. So I think this was the session for today, and tomorrow we'll be starting with case studies on this relative party. Some of the case studies we have already seen, but we'll be dealing with 2 detailed case studies tomorrow on this PUFE transactions. Till then, any questions you can ask. I think now I can unmute all. किसी का भी कोई क्वेश्चन हो तो पूछ सकते हैं आप. हाँ जी, धर्म सिंह जी, आपके एक्सपर्ट कमेंट्स आए हैं.
सर ये भी एक क्वेश्चन है मेरा. एक
हाँ,
क्वेश्चन है, आप कल क्या क्या कवर करेंगे? कल कौन कौन से सेक्शंस और कवर करेंगे अपार्ट फ्रॉम द केस स्टडीज ऑन फ्रॉडुलेंट ट्रांजैक्शन?
बस ऐसा है, कल तो यही कवर करेंगे हम, फ्रॉडुलेंट ट्रांजैक्शंस और रिलेटेड पार्टीज ही कवर करेंगे. अगर उसके बाद
सर इसमें दो तीन सिचुएशंस हैं, लाइव सिचुएशंस हैं व्हिच आई एम फेसिंग.
बताइए बताइए बताइए.
आई एम अ लेंडर.
ओके
हाँ
ओके
सर.
ओके.
इसमें क्या है कि वी हैव लेंड टू कंपनी ए whose associate या सेम प्रमोटर कंपनी was कंपनी बी.
ठीक है ठीक है.
B has given a letter of comfort.
Okay.
And A defaulted.
ठीक है ठीक है.
ठीक है. We went into arbitration with A.
देखिए ऐसा है कि this letter of comfort we have to see whether it is covered under guarantee or not. I don't think it will be covered under guarantee. So that is one aspect we have to see.
बोर्ड बैक्ड है, उसमें इंश्योर वर्ड लिखा हुआ है. It is a board resolution backed specific letter of comfort.
Sir, it won't be covered as guarantee.
Yes, that is the problem.
It won't be covered as a guarantee.
Because we have to see the definition of guarantee.
Is only
yes,
a cushion.
एक मिनट मेरी बात सुन लीजिए.
हाँ, please.
In arbitration, we went into arbitration against A, B promoters, etc.
Okay.
So in the arbitration, through a consent order, B offered some of their properties.
Okay.
As security for the loan given to A. Now, the company B, there is a high chance will get accepted under IBC.
Okay.
Okay. If we get a court order from the High Court for execution of our arbitration award, original arbitration award, then it will be covered under preferential transaction.
No, not necessarily, because Section 43 specifically says that it will also not preclude any transfers made in pursuance to court order. So the RP or the liquidator has to take an independent view. But even despite the court order, the RP or liquidator may feel that it is a preferential transaction, because Section 43 specifically covers this thing. And regarding this letter of comfort, we have to see whether it is covered under the definition of guarantor or not. The definition of guarantor, I think, is given in Section 79. So in Section 59, you have to see. I don't think this is covered under the definition of guarantee. Dharam Singh ji.
79.
हाँ जी, Section 79. Section 79. हाँ, you have to see. Guarantor, it says, see section 78. Section 78 says, guarantor means a debtor who is a personal guarantor to a corporate debtor and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So first of all, he has to be a personal guarantor in respect to a corporate debtor and in respect of whom guarantee has been invoked by the creditor and remains unpaid. So first of all, we have to see whether it is a corporate person who has given the guarantee or it's an individual. First thing. If it is a company which has given the guarantee, then it is a corporate guarantor. If it is an individual, then it is an individual guarantor. If it is an individual guarantor, we have to see definition as per section 70. This is given in application to adjudicating authority for insolvency resolution process for personal guarantors to corporate debtor. This is given in section 78, I think. Application to adjudicating authority. And it says regarding guarantor, guarantor means a debtor who is a personal guarantor to a corporate debtor and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. And regarding this corporate guarantor, I think definition will be given in section 5 probably. Let me see section 5.
I think they can succeed as a mortgagee, but not letter of comfort, that won't cover in any way.
इसमें नहीं आएगा.
Because it has to be a lawful contract.
Yes.
Where both parties have terms and conditions and it is legally enforceable. Letter will not be legally enforceable.
बिल्कुल. And corporate guarantor means a corporate person who is the surety in a contract of guarantee to a corporate debtor. This definition is given in section 5, subsection 5A. हाँ जी, धर्म सिंह जी, आपके concluding remarks, बाकी rest we can discuss in group.
Sir, I have a question.
हाँ जी, पूछिए सर, पूछिए पुष्पराज जी, please.
That the concept of related party.
Yes.
We are examining in the light of PUFE transactions.
Yes.
That means only the transaction made by the CD will come into play.
Yes.
If they are PUFE transaction.
Yes.
But Ramlal is only an RP. So if he appoints his relative as a forensic auditor, it doesn't fall under PUFE transaction.
No, but actually he will be covered by professional ethics also, no, code of ethics also.
Covered under professional ethics, but not as a PUFE transaction.
Yes, definitely.
Yeah. Okay, sir.
But he is obviated from deputing his relatives, no? He cannot.
But here we are examining the sections we are considering is under PUFE transaction only.
No, not to that extent, because it will be a mix of all these things, no?
Okay.
For regulation 27 is there.
This RP will be governed by code of ethics also, no? So as per code of ethics, so he is obviated from appointing any of his relatives as.
Whenever he becomes RP, after that he could, sir. Whenever he becomes RP, after that he will guided by the ethics.
Yeah. Under ethics of RP, he will be.
Yes. He cannot.
Not permitted.
तो सर मेरी एक थोड़ा सा रहेगा व्यू कि हम जितने भी केस लो जैसे आज स्टडी की है हमने, तो सामने मैं तो देखो फर्स्ट टाइम एक आईपी की तैयारी करने चला हूँ, तो मेरे भागते हुए नजर आए थे, ठीक है। तो आप जितने भी केस लो है हमें पहले दे दिए जाए, हम डे टाइम में स्टडी करें उसका
नहीं, ये तो सारा हमने डे टाइम में सब कर दिया था, आपको मटेरियल भेज दिया था।
मेरे को भी मिला था, इसलिए मैं लेट
आपको शायद लेट मिला, नहीं तो हमने तो दिन में भेज दिया था सबको ये।
हाँ, और एक बस ये एडवांस में पता चल जाए ना कि आज इस चीज की क्लास और हम तैयार होके बैठ जाएं।
बिल्कुल
बहुत अच्छा तैयारी कर पाएंगे सर।
तो आज का
too much to read. It is too much to read. It has taken almost more than half a day for me.
No, that is true. That is true.
But now I think 70% जो क्वेश्चन जो इन्होंने लिया केस स्टडी का, तो वो बहुत टेक्निकल है और वो उसके लिए बहुत एक्सपर्ट नॉलेज भी चाहिए।
Correct.
possible.
For that, what you have to do is you have to open the book and you have to yourself find out under which particular section, under which subsection this will be covered.
Yes, sir.
And we can discuss this in the group because the course is very voluminous, and here our focus will be on case studies, and we are presupposing that you already know IBC to some extent.
Yes, sir.
But our worry is whether in the exam we will
Yes.
be able to recall all these things.
No, that
Syllabus
is
is so very voluminous.
No, that is true. But at
While
least
reading, we feel that we have understood.
No, that is true.
But in the examination, whether we will be able to recollect.
Actually, we'll try to give you some.
Because it is so very voluminous.
We'll try to. We'll try
from
to.
your point of view, from my point of view.
No, that is true. But we'll try to develop some good case studies. Let us see how it proceeds.
मैं कह रहा हूँ कोई भी चीज डिस्कस कर लेते हैं या रीड कर लेते हैं या सर से सुन लेंगे तो वो रिकॉल तो होनी है. दिस इज अंडरस्टैंडिंग कि हम कितना उसको ध्यान से सुने, अच्छा रहे तो सर कोशिश करेंगे सर पूरा.
हाँ जी, बिल्कुल. हाँ जी. तो rest of the things we can discuss in the group, है ना? हाँ. And tomorrow same time, and every day the class will be at the same time, whether it is Saturday, Sunday, unless you are notified in the group. And if there is any holiday in between, then we'll extend the sessions further. Minimum 20 we'll be taking, maybe even more. So thank you.
Thank you, sir.
हाँ जी.
Very good session. Thank you, sir.
Thank you, sir.
Good, sir.